Hello and welcome. My name is Colton Totland. I'm an honors attorney with the League of Oregon Cities. I'm here today giving a pre-recorded presentation on the use of social media by governments. So as you can see here, the title of the presentation is Social Media and Government, a look at the benefits and risks of social media for Oregon cities. A quick overview of the presentation. First, we'll be starting with basic working definition of social media, followed by an examination of several laws that apply to the use of social media by cities. First, Oregon Public Records Law. Second, Oregon Public Meetings Law. And third, free speech rights under the Oregon and US constitutions, which can come up from time to time. We'll be looking at two important issues in particular, the use of personal accounts by staff and public officials who are affiliated with the city. We'll also be looking at content moderation, which is establishing rules and parameters for what types of comments will be allowed on a social media page. I'll also include several examples of social media policies from the state and other cities that I think are good examples for cities to consider when drafting their own policies. And a quick note, this presentation will not focus on employment law issues such as problematic use of social media by employees. This is more of an issue that CIS considers. They often get involved when there is some sort of employment-based dispute. So let's start with the definition. What is social media? I think for most of us, when we think of social media, we're probably thinking of Facebook and Twitter. They're the two most commonly cited examples of social media. But it can be difficult, other than mentioning those two platforms, to really get a good idea of what social media is. So for our purposes, I'd say there are three main features of social media to consider. The first is it's a form of electronic communications. That's obvious. It's all taking place online. It's also a form of electronic communication that's widely accessible to the public. So unlike an email or a text message, these communications can be seen basically by anybody with an account on the platform, and accounts are typically very easy to create. And the third, perhaps core feature of social media is that it's interactive. It allows people who are viewing the communications to thumbs up or share or reply in some form. So something to consider, in addition to Facebook and Twitter, are certain city websites. Many city websites have city blogs that resemble social media in those three main ways. I'm going to click a link here to one example, the City Green blog, which is hosted on the City of Portland website. And here's a post from 2018 or 2015, excuse me. Pretty interesting subject matter for anyone who's a gardener or plant enthusiast. We're talking about an invasive species here, the Japanese butterbur. And as you can see, it's electronic communication. It's available to anybody who accesses the Portland City website. And here at the bottom, we see comments from residents of Portland or from wherever engaging with the city on this topic. So in this sense, while we may not consider our city websites to be a form of social media, it's definitely something to keep in mind, that when we talk about the advantages and risks of social media, that that we know exactly what it is we're talking about. Sometimes we're talking about our own city websites. And to get around some of the confusion about what is or isn't social media, it's a good idea for cities to define the term for themselves through a social media policy. So a good example of this is the city of Tigard. Uh, the city of Tigard adopted its social media policy, and it defines social media as an umbrella term for various forms of communication, whether it's text, audio, or video, published in a shared online environment. And it includes as examples, not just Facebook and Twitter, but any blog, microblog, website, any number of things that could constitute social media and could trigger the city policy. So the benefits of social media are definitely worth covering here. Cities benefit from social media in two major ways. The first is that it allows cities to broadcast information and other information, broadcast notices and other information to residents. This is important given that some of the traditional methods of publicizing information maybe don't work as well in today's age. You know, it used to be we would turn to um, posting information in a local newspaper or posting it in a public place. Well, nowadays, not as many people read the newspapers, and there's a lot of stuff that can be done online without ever having to set foot in a public place. So using social media as a way to publish information is definitely one of its major advantages. The other benefit that cities derive from social media is they can receive feedback from residents on any number of topics. This is important because cities are always looking for ways to increase public engagement in local government. And so social media can help with that. In general, social media is a fast, or can be a fast, affordable, and effective alternative to other forms of communication. And again, when we talk about public involvement, some of the traditional methods there would be maybe a public survey. And again, maybe those don't, you know, if it's going out by mail, maybe that's not going to be as effective in today's age. So there certainly are these benefits, but there are also concerns for cities in the realm of social media. And that's what the rest of this presentation will focus on is what are the concerns so that cities can prepare and avoid those issues. So the first set of laws to look at when we're dealing with social media is Oregon Public Records Law. And as we know, Oregon Public Records Law applies to cities in two major ways. The first is through public records retention requirements, and the second is through the requirement for cities to respond to public records requests if they get them. So the natural questions are, first, what social media content needs to be retained? Second, what social media content can be requested? And if we're looking here under the first question, the minimum requirements for retention are listed under Oregon Administrative Rules, Chapter 166, Division 200. And this retention schedule does not lay out a specific requirement for social media content, but it does specify requirements for the type of content that you might see on a social media page. For example, communications and distributions or complaints received by the city. As for the second question, what social media content can be requested by the public? Essentially anything that pertains to the conduct of the public's business. This is the definition under ORS Chapter 192 for what constitutes a public record. And in my view, any content that is posted on a city-operated account is the product of city resources, local resources, and therefore is related to the conduct of public's business. So therefore, I mean, for this reason, I would think that anything that's posted on a city social media page is going to be something that can be subject to a public record. This would include social media content that no longer needs to be retained, but can still be accessed on the website. This is something to keep in mind. Just because it no longer needs to be archived under the retention schedule doesn't mean that it can't be requested by an individual. And oftentimes you can access very old posts on a social media page. So that's something to keep in mind. Another example would be direct messages or posts that are made on other users' pages. These are, again, if they're coming from a city-operated account, they most likely pertain to the conduct of the public's business and can be requested by an individual. They also can be difficult to track down for a city, particularly posts made elsewhere on social media. If the city is not keeping an accurate record of this, this could be a challenging request to respond to. So keeping this in mind, that these can be subject to a records request, and limiting these types of messages and posts will make life easier for cities. So I touched on this already when talking about city-operated accounts. That is one type of an account that a city can have. It would be a city's main Facebook page or a department's Twitter account, for example. These are social media accounts that the city holds out as run by the city. The other type of account would be the private account of an official who works with the city or perhaps a city manager. These accounts can sometimes fall under the scope of Oregon Public Records Law. And so that begs the question, to what extent are they subject to regulation under state law? And the answer to that is it's going to depend on how those private accounts are being used. If Oregon courts have not weighed in much on what is or isn't a private social media account, we do have some guidance from federal courts. When we talk about social media, it's an area of law that is just now reaching the appellate level of federal courts. And so, we're just now starting to get some idea of how laws and state and federal constitution, how these are going to apply to the use of social media. So one example of these cases is Campbell v. Reich, which is from the 8th Circuit, decided earlier this year. In this case, a Missouri lawmaker owned a Twitter account and was found to be running a private account, not a public account, and was therefore protected from liability under free speech clause of First Amendment. In Campbell, the lawmaker had opened her Twitter account before she was elected to office, and she used her personal information to open the account. The court found that the lawmaker had been using the account to promote herself, position herself for electoral success, but not to conduct official government business. And the court found that her posts were to show voters that she was actively advancing and advancing her agenda and fulfilling her campaign promises. The court did caution, though, that a private account can turn into a governmental one if it becomes an organ of official business. So if we compare that case with Davison v. Randall, which is from 2019, This case involved a county commissioner who was found to have violated the First Amendment by banning the resident from her Facebook page. In this case, the commissioner's page was categorized as a government official page, which is an option on Facebook to label, to categorize your page in some form or another. This commissioner had categorized her page as a government official page. The commissioner had used the page to notify the public about upcoming county board meetings and other public meetings. And the commissioner had used the page for various other aspects of her role as a commissioner, informing county residents about public safety issues, coordinating a response to a snowstorm, and advising the public about official actions being taken by the board. The court found that in this case, the county commissioner's page was more or less a public forum and fell under, the free speech clause. But when we're talking about whether or not a page is public or private, these cases can shed some light. It's worth noting that Davison and Campbell are not binding case law in the Ninth Circuit, but again, these are just an example of what a court will find to be a public social media page. And I imagine the analysis would be very similar if we're looking at pages under the Oregon Public Records Law, for example. So the state's interpretation of Oregon Public Records Law is that social media posts are considered public if they are made on an official public agency account. This would be comparable to a city-operated account that I was describing earlier, or on a private account that is being used to distribute information for that agency to the public. And moreover, if a private account is used to conduct government business, then it becomes public and is subject to Oregon Public Records Law. So again, very similar to what we're seeing from the federal courts, here again reiterated by the state to its agencies, that if a social media account is being used to more or less perform the duties of office, it will be something that's subject to a public records request and public retention schedules. So again, it can be helpful for cities to set rules for the use of social media, private social media accounts, through a social media policy. The city of Florence has done this, and in their policy, they say that employees may choose to host personal social networking sites, but they must remain personal in nature and must be limited to non-work related information. The policy goes on to say that any posts made on a private account should be made in that individual's personal capacity, not in his or her capacity as a city employee or as a city official. So more information about the retention of social media. Once we've determined what is public, what is private, once we know what needs to be retained, the question becomes, how do you do it? It can be kind of difficult because it's not like traditional information. It's not emails or paper that cities work with all the time when dealing with retention. Instead, it's on a third-party platform. So how can a city go about keeping this information and preserving it as is required by state law? So the first question that cities need to ask here is what retention period applies to the content. Once the city knows what retention period applies, then they can go about selecting the manner of retention. As we noted earlier in the presentation, there's no specific schedule for social media content. It's going to depend on the nature of the content. The one example is, let's say a city posts the date, time, and place of a budget hearing on Facebook. This is going to likely be a public notice record with a minimum retention period of 3 years. Let's say another example, a city tweets about 2 new volunteer opportunities with the city. This seems more like a routine news release with a minimum retention period of 2 years. So these are a couple examples. Also, as noted earlier, communications and distributions, complaints. These, depending on what is on depending on how you could categorize the information on your social media page, different retention periods will apply. And so, so that is really the starting point, is to figure out how long you're going to need to keep that type of information. Once you know how long it needs to be kept, we look at the manner of retention. And state law requires that, only requires that cities maintain a public record. It doesn't require a specific method. State law even states that however a city retains its information is without regard to the technology or medium used to create the record. In other words, cities have options when retaining their public records. Now, most social media platforms provide users with an option of downloading their activity. These archiving tools can be difficult to use. They are subject to change because they're offered by the platform. The platform can change how they do things at any point. And it may not produce a complete record, especially when we're talking about direct messages or different types of activity on the website. It could be that the archiving tool doesn't catch everything. So in general, I would recommend that cities avoid reliance on these archiving tools and look elsewhere. Cities can always keep a local log of social media activity by drafting any writings in Microsoft Word or by taking screenshots of social media activity after it's posted. I would note here that any log kept by the city should include the date and time of the activity, so that if that information is requested by an individual, they'll be able to see the date and time. And the third option is that some companies, such as Archive Social and Smarch, offer social media archiving services and do the work for cities. These services are designed with public records laws in mind. Just about every state in the country has some form of public records law requirement and retention requirements. And so these companies know about those and retain information for cities with compliance in mind. Of course, these do cost money, so that is a consideration for cities. Other recommendations for cities, based on existing policies across the state. First, I think it makes sense for cities to require that social media accounts be created with city email addresses. This ensures that the city will always have access to its social media account and can help track activity. For example, the city of Florence has stated that social media sites must be developed using a city email address, which is directed to staff in the city manager's office to archive all messages received from the site. So this, again, when we're talking about tracking activity, a lot of platforms email the account, the email account that's affiliated with the account, social media account, every time something happens on the social media account. And so that can be one way to keep an eye on and have a record of everything that's happened on the social media account, is to monitor the email. And again, when we're talking about ensuring adequate control, let's say city employee creates a city's social media account with a personal email address and then leaves the city, suddenly there's no guarantee that the city will be able to access that social media account any longer. And so using city email addresses avoids any sort of issue there. Second recommendation is just to limit the number of social media accounts. City of Ashland has come up with one way of doing this. Their policy states that departments desiring Facebook pages separate from the city account must submit a request in writing to the administration department stating why the main Facebook page does not meet the needs of the department. So this is a helpful way of limiting the amount of social media accounts floating around, and can limit the city's exposure to compliance issues. In the same vein, a city can limit the number of individuals who may post content. This is, again, sort of a straightforward idea. The City of Albany's policy requires departments desiring social media accounts to select representatives who are authorized to post information. So by limiting the number of individuals involved with posting content, you limit the amount of content, or you at least limit the chance for content to be posted and without the city being aware of it. Finally, as noted earlier, I would just encourage cities to avoid sending direct messages or commenting on other social media accounts to make life easier for both retention and for public records requests. So that's Oregon Public Records Law. I have one quick slide on public meetings law. And we'll start here with the definition of a meeting, which we're all most likely familiar with. The meeting is convening of a public body to make a decision or deliberate toward a decision. And it's important to note that any meeting, which is held through telephone conference or video conference, these all must be conducted in accordance with public meetings law, which is to say, Oregon Public Meetings Law applies to a meeting regardless of where it's held or how it's held. And so that would apply to a meeting that takes place on social media. So social media accounts are also, as we noted, broadly accessible, including to other members of a public body. And this creates the possibility that if there are posts from multiple members of a public body on city business, this could easily constitute serial communications that trigger public meeting requirements. Let's say, for example, you have a 5-member public body. 3 of them post about a public topic, city matter, on social media. These posts can be seen not just by the individual posting it and their constituents, but also by the other 2 members of the public body who posted content on social media. And so there you have sort of, the court could infer from that the 3 individuals who are posting about the topic are seeing each other's comments, and this constitutes deliberation. And so to avoid this, I would strongly encourage cities and public officials to avoid commenting anything online about a city topic, and save that for meetings, that have been properly noticed. Save them for meetings of the public body. And a quick note: anything that triggers public meetings law is also going to trigger public records law, which we covered in the first portion of this presentation. So just note that these public meetings law are in addition and on top of the public records law requirements. So the remainder of this presentation now will focus on the free speech aspects of social media platforms. The interactive nature of social media platforms is what poses the risk of liability to cities under a free speech clause. Free speech clauses of the US and state constitutions. User replies and comments on a city's social media page typically are going to be protected forms of speech, and so cities can run into trouble when moderating that content. Let's look first at federal law. The First Amendment to the Constitution is the basis for the free speech claim. Congress shall make no law abridging the freedom of speech. States and cities are bound by the First Amendment through the 14th Amendment, which prohibits states from denying due process of law to US citizens. The important thing to note here is that just as much as federal governments, federal agencies can be liable under the First Amendment, so can states and cities. Now, any person can sue to enforce their First Amendment rights under 42 USC Section 1983. They can seek injunctive relief, may even seek an award of attorney's fees under that statute, and under Section 1988, which is incorporated by 1983. Officials and employees are generally going to be entitled to qualified immunity, meaning that they won't be subject to monetary damages. But an individual can still sue for injunctive relief under 1983, and a city itself can be held liable for monetary damages if a free speech violation results from a widespread practice, one that is, quote, so permanent and well settled that it constitutes an unwritten policy. So with this in mind, it's important for cities to establish constitutional policies that avoid free speech claims arising from social media comments in the first place. So free speech, like any other right under Constitution, it can be regulated to some degree. And arguably, social media platforms are limited public forums under federal law, which means that they can be subject to content-based restrictions. An example of that would be, let's say a city could theoretically moderate social media content on the grounds that it's off topic or irrelevant. Unfortunately, here in Oregon, this type of content-based restriction is generally not allowed because of the Oregon Constitution, which has a separate free speech clause and which has been interpreted to mostly prohibit any type of content-based restriction, with very few exceptions. So what that means is that in Oregon, any restrictions on speech that a city imposes need to be content neutral. A city can prohibit certain outcomes, such as a disruption in a city meeting, but it can't do so by targeting certain types of content, the content of speech. Now, this is a very difficult framework to apply to a digital forum because just about all of the behavior of individuals posting on the site or engaging with the city on the site is content. It's written word. And so courts are working to modernize free speech holdings for social media. And again, this is where we're looking to these recent cases in the federal circuits to give us some guidance. Perhaps the most helpful case for Oregon cities at the moment, and again, this is being recorded June 7th, 2021, is Garnier v. O'Connor Ratcliffe. This is a California district case. This case involved two school board members who maintained Facebook and Twitter accounts, and in 2017 blocked a couple of parents from commenting on their pages. These parents had more or less spammed the school board members' accounts by posting the same message 226 times on one of their Twitter accounts while scrolling through old tweets. And so in response, the school board members blocked the parents. The parents then remained blocked for more than 3 years. Now, in this case, the court held that blocking the plaintiffs for 3 years was excessive and violated the free speech rights of the parents. But the court also held that the initial blocking of the users was appropriate because their behavior amounted to an actual disruption, something that was unduly repetitious or largely irrelevant. And the court categorized that user behavior that is largely unreasonable is behavior that a city has a right to respond to, hinting that there could be other types of behavior on a social media page or in a public forum that can be regulated. Finally, the court noted that content moderation is a challenging role for cities that involves a great deal of discretion, and noted that public officials should not be scared away from social media platforms, particularly as they seek to increase public's access to government. So noting that there is a tremendous value in social media for cities and that these risks of liability shouldn't deter social media platforms. So this case is currently on appeal to the Ninth Circuit, and we will know more, hopefully, when the Ninth Circuit issues a holding on this. In the meantime, and in general, the types of restrictions that are likely going to be permissible on a city social media page are restrictions that limit disruptive behavior, such as high-frequency posting or repetitive posting. This is the type of stuff that we saw in Garnier. Similarly, posts that are unintelligible, that don't make any sense. If someone were to just spam their keyboard, this is the type of content that could be restricted. Another type of restriction that is probably permissible is any posting that creates a hostile or unhealthy environment online. Any postings that are sexually explicit or that depict excessive violence, the more largely unreasonable, quoting Garnier, the easier it is going to be for a city to make the case that it doesn't belong on the social media page. Also, no encouraging or promoting criminal activity and no advertising. These are areas that traditionally governments have more leeway to regulate. As a rule of thumb, I would encourage cities to treat their social media pages as they would a council meeting or any other public meeting. Whatever would be permitted at such a meeting as same sort of stuff that can be permitted online, and what you can't get away with prohibiting at a council meeting, you also can't get away with prohibiting on your social media page. So that can be, as I said, a rule of thumb. Now, the types of restrictions that are likely impermissible are, again, note off topic or irrelevant comments. This is a content-based restriction that we just typically don't see here in Oregon because of Article 1, Section 8 of the Oregon Constitution. I also would discourage cities to prohibit profanity on their social media pages, or certainly if it's mild profanity, that's the sort of thing that even under federal law likely is not going to justify deleting or censoring or blocking an individual from a social media page or from any sort of public forum. So keep that in mind. In conclusion, I would say that social media definitely makes it easier for cities to inform residents about city topics, such as meetings or volunteer opportunities. It also allows for two-way communication with the public through interactive features like likes, shares, retweets, comments. If properly managed, social media can be an effective tool for engaging with the public, but social media can also create a real risk of liability for cities. And so I strongly recommend that cities adopt social media policies to delineate between what is a public and private social media account. And also, where practical, we recommend that cities disable the comments feature on their social media accounts. This limits the city's exposure to free speech claims and still allows for one-way communication with residents, which, the publication aspect of social media. So here is my contact information, my email address, and my phone number. If any of you watching this have questions, don't hesitate to reach out. Thank you for tuning in for this presentation.